Good day to you. This is Graham Paddock, and I welcome you to another Paddocks Club tutorial.
In this tutorial, designed for managing agents and involved owners and trustees, I will be looking at the changes brought about by the Sectional Titles Amendment Act, number 11 of 2010, that deal with management issues which are not financial in nature. In item 1 of the Amendment Act, the definition or the qualification of the definition of a unanimous resolution contained in section 1(3)A is amended, and the words subject to are taken out and the word notwithstanding inserted. So the effect of this is to make it clear that if a proposed unanimous resolution may affect an owner's proprietary rights, that situation is not a bar to an application to the High Court by the body corporate. Once the Community Scheme Ombuds Service is operational, this type of application will be made in terms of that legislation. Item 2 brings a welcome end to the old chestnut issue of the legal nature of windows and doors, i.e., are they part of the section or are they part of the common property, and exactly how is that whole thing handled? Well, here in a proviso, which is taken is a copy from parts of the Australian legislation, is a provision that any window, door or other structure that divides a section from another section or from common property is considered to be part of that floor, wall or ceiling. This means that wherever they are situated in the width of the walls or the doors and window frames are always considered to be half section and half outside the section. That might be part of another section, or it might be and will normally be common property. This amendment brings a welcome clarification to the maintenance obligations of owners and body corporates in regard to these items that do require regular and sometimes quite costly maintenance. The next item is a reworking of the 10% deviation threshold that applies when a section is to be extended. And this welcome amendment here does a number of things which I'll unpack in a second. Firstly, it makes it clear that the participation quota deviation applies to the section itself, and that was a necessary clarification. Before it was argued that the 10% deviation might apply to any section or to all the sections in the scheme. It's also more sensible to have a land surveyor or architect certify the extent of the deviation, because obviously a conveyancer isn't trained for that sort of thing. But this does mean that the certificate can only be given at the time that the draft sectional plan of extension is prepared, and that of course can only be prepared once the extension, the building works, are completed. So when considering an owner's request for a special resolution that authorizes the extension of a section, a body corporate should bear this in mind, and it might make sense to ask that the bondholder's consents be obtained in advance. Otherwise, you could end up with a situation where the extension is completed, the sectional plan of extension is ready to go, but there are bondholders who won't agree for some good reason. And as we'll see in the next change, they are going to have an opportunity to have a look at how an extension might affect their rights and the rights of the person whose property they hold under the bond. This also does, I think, open the opportunity for banks. I mean, there are only 4 or 5 major banks that give bonds in this sort of situation, at least at the moment. But so in a big scheme, it might, I think, be possible to get one consent from a bank for all the sections that it has in that particular scheme. So that's an improvement, I think. Item 7C of the Amendment Act details the process for notifying bondholders and for providing an assumption of consent if they don't object within 30 days. This is pretty radical stuff, I think, because we're introducing a provision nowhere else in the Sectional Titles Act that when you give somebody a notice, if they don't respond within 30 days, they are deemed to have consented to that extension. I think that this will work in practice. But I think it is interesting that when giving notice, the person who wants to extend their section has to give the bondholders an assessment of the impact of that extension on the bondholder's security. Now, in many cases, that impact will be very little. But in other cases, more especially when there's a delicately balanced participation quota situation, it might be that that will in fact affect a bondholder's security quite substantially. If a bondholder fails to give consent within the 30-day period, there is no provision for him to come back and to cure that situation. So I think there could be some difficulties with this, but I think we'll all get used to it. The overall view I have is that this treats extensions as if they're fairly minor things, and in many cases they are, but every now and again an extension can be quite a massive thing. And this I think is a little bit of a quick and dirty exercise as far as bondholders' consents are concerned. On the other hand, as Professor Corny van der Merwe has noted, this will enable a number of schemes where irregular extensions have been made over previous years to cure that situation, and that is certainly to be welcomed. The next provision in item 8b is for the extension of a Section 25 future development right holders time period. So by way of a notarial agreement registered before and registered in the deeds registry, it is possible now to extend the original period set by the developer when he or she takes out future development rights. And this also allows for a new concept, that is that a developer might reserve rights of exclusive use in regard to an existing building. It doesn't always have to be in regard to new buildings. So it's possible under this change provision that you might open a sectional title register with various areas of common property building that could subsequently be developed by the creation of exclusive use rights in those buildings. The next change in item 8H provides for a cession of additional real rights to exclusive use areas within 12 months. Now, not allowing the developer to hold on to the exclusive use rights in the longer term is, I think, sensible, because the very nature of exclusive use rights is that they are the result of an agreement amongst co-owners as to how they will share the use of their common property. And of course, the developer in that capacity is not a co-owner. For the same reason, I see cessions of exclusive use areas to the body corporate, which is one of the features of this provision, to be only a temporary solution. These rights should, once they have vested in the body corporate, they should have to be destroyed or ceded to specific owners within the scheme in a relatively short period. That's my view. In item 8M of the Amendment Act, this extended the developer's obligation to implement a future development of this scheme strictly in accordance with the reservation plans. It extended that not only to the buildings but also to the exclusive use rights, and that I think is a sensible thing. In item 9A, there's a provision for a developer to confer all reserved exclusive use rights on owners. Now, this thing's a little bit more problematic, I think, because it was intended to prevent a developer opening a register with a sectional plan that shows exclusive use areas without taking title to those areas, i.e. the mischief to be addressed was that some developers were only partially implementing the sectional plan. But in actual practice, the imposition of a condition reserving future exclusive use rights doesn't in itself cede those rights to anyone. The condition simply creates the rights, and they vest in the developer at that stage. It is by the subsequent cession of those rights that they're actually conferred on the owners. So in my view, this provision is improved, but it still needs a bit more work. In item 9B of the Amendment Act, there was a provision for the vesting of rights to exclusive use areas where an owner ceases to be a member of the body corporate by also now saying that it is free not only of mortgage bonds but also of any other registered real right. So that means that if an exclusive use right under Section 27 were subject to a registered lease, for example, and the holder of those rights ceased to be the owner of a unit in the scheme, the registered lease rights would also disappear. Finally, in item 12, there's an extension of an owner's obligation not to use an area for purposes other than shown on the registered sectional plan. Now that sounds fairly familiar, and it is, because that is a provision which is already contained in the prescribed management rules, but it's certainly an improvement to have it put into the Act. Unfortunately, the way it's been drafted, it only refers to registered sectional plans, and therefore it only applies to Section 27 exclusive use rights. And as you know, by far the greater number of exclusive use rights and areas are conferred and created in terms of scheme rules. So this could be improved by adding a reference to the scale plans attached to rules made under Section 27A.
Thank you very much for watching this Paddocks Club tutorial.